We are looking at question 5 from the February 2024 California bar exam, the last 1-hour essay of that exam. So this is the second essay in a 3.5-hour time block. The time is not structured for you. You're given 2 essays and 1 performance test, and the suggestion is that you leave 90 minutes for that performance test. Our mantra is 1 hour, 1 essay on the California bar. And generally I find that essay 5 is really complex, and people often run overtime on question 5, and then they have less time than they need to do the performance test. Here I see only 2 calls. Call 1 asks, is there an enforceable contract between Brian and Sam? If so, what are the terms? So that call tells me that this is contracts and that the fact pattern centers around formation of the contract. Call 2 asks, is Brian likely to prevail on his claim against Sam? If so, what damages is he likely to recover? So I'm not being asked about specific performance. I'm just being asked about damages. So that makes me think that the formation issues are going to be pretty complex. Otherwise, it would have been a broader call about remedies, and I would have had to write specific performance with all its elements. They've narrowed it to damages. I think call 1 is the huge call. Let's go to the facts and figure out what we've got here. Brian, owner of a commercial bakery, and Sam, owner of a bakery supply business, met for the first time and discussed Brian's inability to find a reliable source of maple topping. When Sam told Brian he could supply the maple topping, they orally agreed that Sam would immediately ship 500 gallons of topping at $20 per gallon. A lot going on there. First of all, it's a UCC contract. It's the sale of goods. That's always the first issue in a contracts essay. You have to establish choice of law, UCC or common law. So my first head note is always applicable law. And then, if it's UCC, you have to think about whether there are merchants involved. Here there are, because there are special merchant rules, and I expect this hypothetical to hit several of the areas where the rules are slightly different for merchants than they would be for non-merchants. For example, UCC 2-207, different or additional terms. And they tell me that they orally agreed. So I think that statute of frauds is going to be a huge issue. This probably will never be an agreement reduced to writing and signed by both parties. So we're likely going to need to find a way out of the statute of frauds. Now, when I go into a bar exam, I have the structure of the law fresh in my mind in an organized, tight kind of a way. But I don't have that right now because I have not prepared for a bar exam. So I want to go and take a look at the organization of the law that I would have mastered and memorized before I saw this hypothetical. Let's go to Proponix. This is a software platform we developed to hold our schemas so that you could fold and unfold them and study them that way. I'm going to contract law. Applicable law is the first thing I'm going to establish. So the basic rule for applicable law is the UCC governs contracts for the purchase and sale of goods. All other contracts are governed by the common law. And then I see merchants. A merchant is one who deals in the goods or has specialized knowledge of them. We have merchants here. Under formation, a valid contract requires offer, acceptance, and consideration. And here we have the rule for offer. and we see that under the UCC, there can be open terms. The only thing I'm required to have under the UCC is a quantity term. The rest of the terms will be filled in using course of performance, course of dealings, or trade usage. What about acceptance? Under the common law, we have the mirror image rule. So the acceptance must exactly match the offer terms. But under the UCC, we have a different rule. Any reasonable manner or means. And then here I see UCC 2-207, which I suspect they're going to give me a lot of facts to analyze. An expression of acceptance or written confirmation sent within a reasonable time operates as acceptance, even though it states additional or different terms, unless acceptance is made conditional upon assent to them. Well, do those terms become part of the contract? There's a different rule if the contract is between merchants. They will become part of the contract unless, and there are 3 unlesses. The one I expect will be operative is the term materially alters the contract. That's the one they most often test. Or notice of objection is given within a reasonable time. So if you know this law and have it at your fingertips, and you get a hypothetical like I expect this one to be, you can rack up points and press the grader really quickly. Where no contract has been formed, then conduct by the parties that recognizes the existence of a contract is sufficient to establish one. And the terms of the established contract will be where the parties agree. Where they differ, the meaning can be supplemented by course of performance, course of dealings, and trade usage. And of course, we need consideration. There are no real big differences between merchants and non-merchants in the area of consideration. So I'm going to skip over that in running through this law. What about defenses? The big one, the defense to enforcement that they've already flagged for me here by saying orally agreed, is the statute of frauds. Contracts for the sale of goods fall within the statute of frauds and require a writing. For the UCC, that means a writing sufficient to evidence a contract has been made. It has to be signed by the party to be charged, and it has to contain a quantity term. That's as opposed to the common law, where both parties need to sign the agreement and identify the parties, the subject matter, and the consideration. So the big issue is always, how do we get around the writing requirement? What are the exceptions to the statute of frauds? And here we see some UCC exceptions. And look at that. The first one applies to merchants. Written confirmation between merchants. The transaction has to be between merchants. Ours is. The party seeking enforcement has to have sent a written confirmation of the contract that is sufficient against itself. The party against whom enforcement is sought has to have received the confirmation within a reasonable time after the contract was purportedly made. And the party against whom enforcement is sought has to have failed to object within 10 days. So let's see if this applies to our facts. In our facts, Brian is suing Sam. So Brian would have had to send a written confirmation of the contract, and Sam would have had to receive it within a reasonable time after the contract was purportedly made, and would have to have failed to object within 10 days. If I find all that in the facts, then their agreement would be enforceable even without a writing, signed by Sam. Sam is the party to be charged. What other exceptions do we have? Well, I see specially manufactured goods, but I don't think that applies because it would have to be specially manufactured for the buyer, and this doesn't look like it is. Admissions, I see part performance, goods accepted or paid for, and I see estoppel. I also see that the UCC usually upholds clauses that say no oral rescissions. I know that under the UCC we don't need consideration to modify a contract, but that under the statute of frauds, oral modification is invalid unless there's detrimental reliance. All that I already know about modification. What about alternate theories if there's no contract formed? We have promissory estoppel, we have unjust enrichment, and we have accord and satisfaction. I also remember that there are implied warranties in UCC contracts. There's the warranty of merchantability, and there's a warranty of fitness for intended use. And of course, the express warranty, the basis of the bargain. So what else is different about the UCC or about merchants? Well, one big area is the issue of conditions versus promises. In the common law, it takes very specific language to elevate something to a condition. Generally, we're talking about promises. On the UCC, we have the perfect tender rule, and so if there's a date, that's a condition. In the common law, not unless there's specific language. In the area of performance and satisfying performance, the UCC again is different from the common law. And there it is, the perfect tender rule. Under the UCC, generally performance has to be perfect. There are exceptions to that, and there are rules about what happens if tender is not perfect. So you see there that one of the exceptions is if the seller had reasonable grounds for believing the tender conformed. And if performance is not perfect, then the buyer has three options: accept everything, reject everything, or accept part and reject part. So what else might I need? Discharge of performance. Well, not so likely. Discharge of performance includes by subsequent event and by a new agreement. But I do know that I need to know about remedies in particular. So let's go there and go to damages. We have general damages, consequential damages, and liquefied damages, punitives, and reliance. Okay, general damages. They have to be caused by the breach, they have to be foreseeable, they have to be certain, and they have to be unavoidable. That's a basic rule that applies to UCC and common law. Consequential damages. To recover consequentials, those other than expectation, that flow from the breach, they must be reasonably foreseeable or specifically brought to the attention of the defendant at the time the contract was formed. What else might be in our facts? How about reliance damages? When expectation damages are difficult to calculate, or when recovery is based on a detrimental reliance theory, then reliance damages make the plaintiff whole as if there never was any contract. I think that's all I need to look at here. So let's go back to the hypothetical and see what we do have to write about. So they had orally agreed to 500 gallons of topping at $20 per gallon. Sam then added that he did not want to ship without something in writing, and Brian replied, "I will send written confirmation tomorrow." Well, if there had been a contract at that point, then a modification would be fine without consideration, but I don't see a contract yet. This looks like negotiations. For the next 3 weeks, Brian was busy negotiating a conference center catering contract and forgot to send Sam the confirmation. The catering contract obligated Brian to provide large quantities of pastries with maple topping. Notice, this negotiation was going on after their oral agreement, after he had promised to send a written confirmation the next day. So all of this about the contract, this large contract that required him to have a lot of pastries, was not foreseeable at the time the original agreement was made. But we don't have an enforceable agreement yet. Brian then recalled his promise to Sam and sent him a purchase order on his standard form for 5,000 gallons of maple topping at $20 per gallon to be delivered to Brian's place of business in 2 weeks. So where do we stand? Let's go through it a point at a time. Sam tells Brian he can supply maple topping. Well, that's not an offer yet because it does not have a quantity term, and under the UCC it has to have a quantity term. Then they orally agree that Sam will immediately ship 500 gallons of topping at $20 per gallon. Here we have an offer by whom it's unclear, but there is a quantity term here. And Sam adds that he doesn't want to ship without something in writing. Brian says, I'll send written confirmation tomorrow. Okay, written confirmation tomorrow would have done it, except that didn't get sent. So 3 weeks later, we get a communication from Brian that's on a purchase order and calls for 5,000 gallons instead of 500, and it's to be delivered in 2 weeks to his place of business. So if you considered that an acceptance, then you need to analyze UCC 2-207, different and additional terms. Between merchants, which we have here, they're going to become part of the contract unless they materially alter the contract or notice of objection is given within a reasonable time. Well, I would argue that that quantity term materially alters the contract. It's 10 times the amount they agreed on. Does the 2 weeks alter it materially? Maybe not. So I would think the quantity term is not going to become part of the contract, but the time frame might. Is this a sufficient written confirmation between merchants to make the agreement enforceable? Well, it is between merchants. Brian is the one seeking enforcement. He materially altered that quantity term, though. Did Sam receive it within a reasonable time after the contract was purportedly made? That is a problem. That confirmation was promised for the next day. It didn't arrive till 3 weeks later. So argue your facts and decide whether you think that was a reasonable time or not. If you do, then there's an enforceable contract, and I would argue it's for 500 gallons and not 5,000. If you don't, then that sufficient memo exception will not get you out of the writing requirement. Sam received Brian's purchase order but did not notice the change in gallonage. He saw the delivery date, but in light of Brian's delay in sending the confirmation, he did not believe it was firm. That same day, Sam sent a signed acknowledgement restating Brian's purchase order items and then left on a 4-week vacation to a remote locale. Again, a lot packed in that paragraph. So for me, here's where things got really complicated, and it was possible to get really confused. I think that you could have come down either way on whether that purchase order from Brian was a sufficient memo or not. And I suspect the bar graders would give you credit if you decided it was, and so there was a contract because we're out from under the statute of fraud. If, like me, you decided it was not because it was to be sent a day later and he waited 3 weeks, then now what is that purchase order? Well, then it would be an offer. Sam receives it and he confirms all the terms in the offer, even though he didn't realize it was for 10 times the amount of product that he thought it was. Sam has made a unilateral mistake, and that won't void the contract. Why unilateral? Because Brian needs a larger quantity. He knows he does. It appears that upping the gallonage by a factor of 10 is deliberate on his part. So under my reasoning, the purchase order that Brian sent was an offer. When Sam sent a signed acknowledgement restating the purchase order terms, that was an acceptance. And under the UCC, to satisfy the writing requirement under the statute of frauds, we need a writing sufficient to evidence a contract has been made, signed by the party to be charged. That's Sam. Sam signed it. And it has to state a quantity term. He confirmed the 5,000 gallon term. The quantity term is there. His unilateral mistake will not get him out of that acceptance. He saw the delivery date, but he didn't believe it was firm. Don't get confused. A merchant's firm offer is a provision that governs the termination of an offer. It says that if a merchant makes an offer that's signed and in writing and states that it will be held open for a reasonable time, then that offer is not revocable. Brian made an offer to purchase 5,000 gallons. He's not trying to revoke it. So what's going on here is that Sam thinks the date is not firm. The UCC has the perfect tender rule. He left on a 4-week vacation to a remote locale. Looks like he's going to breach by not making that date. Upon his return, Sam shipped 500 gallons of maple topping to Brian. Under my reasoning, Sam has breached. He's breached in terms of the number of gallons, and he's breached the time. And because he's breached the time, there's likely no reasonable way to cure. By that time, Brian was in default of the catering contract due to lack of maple topping. Brian had tried, but had been unable to reach Sam while he was on vacation. Because Brian had been unsuccessful in obtaining an alternate source of maple topping, the conference center canceled its contract, resulting in $100,000 in lost profits. Brian refused delivery of the 500 gallons of maple topping and sued for breach of contract, seeking the $100,000 in lost profit. Is he within his rights to refuse delivery of the 500 gallons? Under my reasoning, Sam breached by not providing the right number of gallons under the contract, and the time for performance had already passed, so there is no time to cure. Brian was entitled to reject the 500 gallons. Now we come down to the 2 calls. How do we answer them? The first one asks if there's an enforceable contract, and if so, what are the terms? Under my reasoning, the way we finally wound up with an enforceable contract was that purchase order sent by Brian to Sam for 5,000 gallons, and then Sam confirming all those terms in writing. That is a huge call. Notice all the analysis I would have had to do to get to that point. And now what about the remedy? Call 2. Is Brian likely to prevail, and if so, what damages is he likely to recover? I think he's likely to prevail because Sam breached in terms of quantity and in terms of delivery time. Is he going to prevail in getting $100,000 in lost profits? I think not, because that would be consequential damages, and that was not foreseeable at the time of contract. If a buyer breaches, the seller is entitled to lost profits, but that's not what's going on here. This is the seller who breached. So what are the buyer's remedies under the UCC? The difference between the contract price and the price to cover, but this buyer could not cover. So then what? Well, incidentals and consequentials. Lost profits for a buyer are consequential damages. For Brian to be able to collect those, he would have had to make the seller aware of the size of the contract he was buying these goods for. In other words, the seller would have had to have been aware of the risk. That did not happen here. So he's not going to get those lost profits. He will get consequential and incidental damages that he incurred as a result of the breach, but not $100,000 in lost profits. I found this to be an extremely difficult UCC contracts hypothetical to answer, certainly in an hour. And I doubt that I could have done a good job of all that analysis in an hour. If your analysis differs, that does not mean it's wrong. The most important thing you can do in analyzing this is to demonstrate for the grader that you know these doctrines, that you know the differences between the UCC and the common law, that you know the special rules for merchants where they apply here, and that you do a reasonable job of analyzing how to get out from the writing requirement or satisfy it under the statute of frauds. If you need to hear a more detailed lecture on contract law, highlighting differences between UCC and common law, check out our Patreon channel. Our contracts lectures are in that channel.